It's tricky though, isn't it? Because as you say, it all comes down to interpretation. So I could take the interpretive response that, well, this is an emergency situation. This is a pandemic. And so I do need to know whether someone is jabbed or not so that I can protect myself, my staff, and my consumers. However, does that then give you the right to discriminate against someone once you do know their medical status? If we go down the line that, well, yes, this is an emergency, I do need to know whether you're jabbed or not. Okay, now I know whether you are jabbed or not. Can I then discriminate and say, well, you're not jabbed, you can't come into my business? The fact that everybody on both sides of the fence agrees that being jabbed does not affect transmissibility, nor does it affect whether you're going to come down unwell with this virus or not.
Yes, absolutely. The FDA have on their website for several months 2 frequently asked questions about transmission, and their answer is that there is no science to support the view that the mRNA vaccine, that Moderna, I've got 2 of them, one for Moderna and one for Pfizer, saying that there is no evidence, science to prove the view that it reduces transmission. There is only hope, and that is based on other vaccines doing it, but this is nothing like any other vaccine. So their reasoning for public safety being based on the fact that they're restricting access to a place based on an increased risk of contagion, saying that you're more likely to get infected and be transmissible, but that is also under the concurrent powers. It is not allowable for a direction to do that. I believe it is, if you just give me a moment, I can quote the exact section, the Biosecurity Act, because under 478, that's the power that the health minister has to call the direction. So directions actually given by the CHO are invalid because section 474 says that the health minister has to do it personally, and 478 talks about the directions that a health minister can use during a human biosecurity emergency period. And inside that, under subsection 6, it details the limitations to that. And the limitations are, but the sections from 85 to 97 are not allowed to be used in a direction. And one of them includes being limited from a place based on an increased risk of contagion that I was just referencing to. And it's just a very long act, and I'm in the 80s. So it is restricting behavior. So this is what they can't do, because there is a process called a human biosecurity control order, where the specially trained individuals through the director of biosecurity can put orders on people to use these 12 sections. So this is an individual may be required by a human biosecurity control order not to do either or both of the following for a specified period. And it is visit a specified place or class of place where there's an increased risk of contagion of the listed human disease. And they're alleging that people who are not vaccinated are more of an increased risk from the contagion of the listed human disease. So they're restricting you from that, which is not allowed to be used in a direction. And there's lots of others underneath there. They can't force PPE on you. Yeah, so that was 87, restricting behavior. They can't require you to do tests. They can't require body samples for tests. They can't require treatment or vaccination. They can't require you use medication. And
so who is they, just to encapsulate that?
This is the human, the health minister can give directions under section 478 of the Biosecurity Act 2015. This is the Commonwealth Act that the Health and Wellbeing Act, or the powers of the CHO, are coming in contradiction with, because the federal government under the Constitution, Section 51, it lays out the powers that the
Yeah.
federal government can exercise, and the state can exercise them as well. But where they come into contradiction, the federal government, Section 109 states, the federal government comes out on top, and the state is limited to the point where it is compliant or excluded. So it's the Biosecurity Act talks about the biosecurity control orders. In at least here in Queensland, they have to do they have to do certificates in Victoria as well. But I was reading through that, and there are ways that they've changed it to make themselves excluded from that. And it's that because they're not doing this, even though they don't do the certificates for the human rights breaches of these directions, it doesn't invalidate them. So it's, yeah, in Queensland, it actually states if they don't do the human rights certificates for these, and that's under the statutory interpretations act as well, because they're subordinate legislation. They're not the law unto themselves, so they get interpreted in a special way. The Victorian ones seem to allow a lot of those checks to be short-circuited. So I don't know exactly how legal that is. In the Legislative Interpretive Act, it does state in Victoria, you can use other states' legislation and overseas legislation as interpreting features to a law. They're intrinsic material that can be used in an interpretation. So, yes.
Okay. So for the person that's listening to that now and hearing lots of different things that are going around, that federal overrides state, things seem to be contradicting each other. The CHO can put something out, but police can't actually enforce that. We'll get into that in a little while. Only health officers with the help of police, et cetera, et cetera.